Yes, and let me interrupt you, Dimitro. That was before Trump. That was before Trump. And I realized my client was likely being driven to the airport to be deported. I've heard enough. Miss Crossley has persuaded me. Leave, go call your client and tell your client to turn that car around. And I've seen a level of incompetency that is shocking. I've seen a level of, let's say, mediocre representation.
Hello, my name is Dimitro, and I'm right here with Adela Crossley,
Adela Crossley.
a lawyer, a barrister, and solicitor who has been helping clients for 20 years to get out of, I would say, the most problematic situations in their lives. And I would like to ask you something about the piece of legislation that recently became law. And this piece of legislation has brought a lot of uncertainty
And stress
to many individuals in Canada. I'm talking about Bill C-12 specifically. And I also like to ask you something about one of the clients who actually was found ineligible for refugee claim because this individual arrived in Canada in 2022, and this individual did not have a reason to file refugee claim at the time, but because of the recent events in 2025 when their family members were brutally murdered in their home country, they actually started to be scared for their life, and that was a trigger to file refugee application in Canada. And this individual filed refugee claim, and as a matter of fact, has already received a letter saying that they are not eligible for refugee hearing, and now they are waiting for their pre-removal risk assessment.
Yes. So thank you, Dimitro. This is indeed a very, very serious concern for many individuals who came to Canada, and maybe at a time that they came to Canada, they did not have a valid reason to fear for their life. I have seen many victims of domestic violence where perhaps the violence occurred in Canada after they had lived here. I have many such clients. And when they experience violence in Canada and their spouse is from their country and perhaps have been deported after being criminally charged in Canada, they file that claim. This individual, I'm well acquainted with him, very sad case where his entire family was murdered in his country because of issues that arose, and then he had reason to fear for his life. But when he filed his claim, waited for his hearing, all he got in return was a letter from IRCC saying he is no longer eligible for a refugee claim. So, of course, many individuals are very stressed. They face a very uncertain time. What do I do? Am I going to be deported? Am I going to have access to a fair hearing? Am I going to have a realistic chance to present my case? And I want to make it very clear. IRCC has stated that for individuals who may not be eligible for a refugee hearing, they will have their risk assessed in a pre-removal risk assessment. It's important to know that there are distinct differences between a PRRA, a pre-removal risk assessment, and a refugee hearing. A refugee hearing is held before the Immigration and Refugee Board, a tribunal that is staffed with specialized board members who are trained. Many of them are lawyers themselves who have experience in adjudicating refugee claims. You have the ability to have your lawyer ask you questions, present, your evidence, and give submissions. A PRRA, in direct contrast to a refugee claim, is all done on paper. You have a single opportunity to present your entire case, all on paper, and your evidence is also provided. It's assessed on paper by a single immigration officer from IRCC. And then you may or may not have an oral hearing. And your claim may be rejected for a number of reasons. Historically, PRRA's pre-removal risk assessment have a very, very low chance of success. Refugee hearings and claims have a significantly higher chance of success. Why is that? I think a lot has to do with the adjudicator, the person that hears the claim, the person that is looking at the national document package, the objective evidence, a person who has more training, in my respectful opinion, and is more specialized to adjudicate risk and the country condition documents. A PRRA officer oftentimes do not cite documents from the national document package, do not look at the objective evidence, and may not come back with a response that clearly reflects the objective evidence and a really good risk assessment. So it's very, very concerning when I find that individuals who may easily win a refugee claim if they had access to the IRB may not win a risk assessment under a pre-mover risk assessment. And individuals are worried, they're scared, and they become very, very stressed. Because at the end of the day, if you have a genuine fear for your life, you're going to do everything possible to want to not return to your country. And so these changes, I think, are important that you speak to a very experienced immigration lawyer. Why is that so important? Because not all lawyers, consultants, paralegals are excellent advocates when it comes to doing written advocacy. So a refugee claim and a PRA call upon very different skill sets. In order to put forward all of the risk on paper, which is what a PRA is, it's all done on paper, you need someone with excellent written advocacy skills. Someone that knows the country condition documents well, the objective evidence, someone that knows the jurisprudence, and someone that is able to articulate that in an exceptional way in written form, because it's probably going to be all in written form. And with all due respect to the wide array of individuals practicing immigration law out there, not every practitioner has those skill sets. So that is a cause for concern for me, because in a refugee claim, and you may get away with that sometimes because you're before a tribunal that is asking questions, that there's a back and forth, not the same with written representations. So, what is missing from written representation? The voice of your client. The voice of your client, that your client gives evidence under oath in a refugee claim, and they're able to articulate, sometimes in excellent ways, the risk in their country. It's very persuasive, it's very compelling to hear a person say, I will be killed if I return, my entire family has been killed. That could be highly persuasive to a refugee board member. In a written form, may not be as effective. Therefore, it is essential when doing a pre-move risk assessment that you choose someone that is suited and have the skill set that is very specialized. And so that's one thing that is a cause for concern because, like I said, not everyone has that skill set.
I would like to ask you something. So, for instance, if this individual is given a PRA, and just imagine for a moment that for some reason the PRA is refused, what would you do? And what could you do for this individual in order to help them in this situation? We also have to keep in mind this individual is desperately afraid to return to their home country.
An excellent question, Dimitri, because unlike a refugee claim that is refused, an individual would likely have access to file an appeal before the RAD, the Refugee Appeal Division, which is a division of the Immigration and Refugee Board. And one of the important benefits of filing an appeal before the RAD, it provides the client with an automatic stay of removal. So imagine if you are genuinely afraid to return to your country, you get a negative decision, but you know that there is an appeal process that is fair, and you have access to it. And while you are waiting on that important appeal process, you are sure that you will not be removed while you are going through the appeal. Unfortunately, Demetrio, that is not the case at all with a PRRA decision. A PRRA decision is a final decision. There is no appeal of that decision. There is only an application for judicial review in the Federal Court of Canada. And unfortunately, while you are waiting on that application for judicial review in the federal court, which you have to file, by the way, within 15 days of getting that negative PRRA decision, there's no automatic stay of removal. There is none. So we could have a situation, and I've seen this happen quite a few times, where a person has filed a judicial review. They file it within the deadline. They do everything and they comply with the law. However, because the judicial review takes a while to get to the attention of the judge, while you are waiting on that process, CBSA may very likely call you in, send you a notice, call you in for an interview, and in that interview, they ask you to buy a ticket to depart Canada. So that is a situation that unfortunately many individuals, increasingly so today, are finding themselves in. It is not a good situation. It is highly stressful, especially if that person has children, has a spouse, and is afraid to return. And so at that point, that individual may have no choice if they want to remain in Canada legally but to bring an emergency stay of removal, what we call a stay motion, and ask the court, the federal court, to stay their removal from Canada pending a decision on their application for judicial review.
Okay, so can you tell me, please, what stay motion is and what documents, what evidence this individual must present to the federal court in order this decision to be granted?
Well, a stay motion is what we call an interim remedy. You're asking the federal court essentially to exercise their discretion and to stay your removal, which the CBSA wants to schedule the earliest possible opportunity, and they have a right by law to do so under the Immigration and Refugee Protection Act. We're essentially asking the federal court to exercise their discretion positively to stay that lawful removal pending the outcome on the application for judicial review. And it's a what we would call in Canada an extraordinary remedy. It is not a remedy that is lightly given. So the Supreme Court of Canada has articulated a legal test that has three distinct components in order to grant a stay of removal. And as the court has stated, it is a conjunctive test, meaning that an applicant has to demonstrate all three components of the legal test. The first thing that is required is that there is a serious issue in the underlying application for judicial review. To put it simply, that your application for judicial review has merit and is likely to succeed. So if you can demonstrate that, then you're one third there. The second issue that you have to demonstrate in a stay motion, and this is the part that is the most difficult to establish, is that if the stay is not granted, you will suffer what we call irreparable harm. Irreparable harm is not the kind of harm that is compensated by money. It is a kind of harm that shows um, risk to you, harm that will cost to you if the stay is not granted. For instance, case law has shown irreparable harm could be debt, it could be inhumane treatment. So it's not something that a court would likely grant if you say, well, it's inconvenient for me to go back at this time. It is beyond that. It is more than mere inconvenience. It is more than mere reluctance to leave Canada. So it's a very high threshold of harm that is needed to demonstrate why you should not return to your country at this time. Then the third prong of the test, the legal test, we call it the tripartite test. It's in three parts, is the balance of convenience. So the applicant has to demonstrate that the balance of convenience favors them and the granting of the stay. On occasions when a person has been actively evading removal from Canada, let's say they don't come to the court with what we would call clean hands. They were asked to be removed from Canada some time ago. They did not comply, and now they come to Canada with a stay motion saying, please let me stay. So the court would look at, did you comply in the past? Your conduct, your behavior in Canada up to that point. If you can demonstrate that there's a serious issue to be tried in the underlying application, the judicial review, if you can demonstrate irreparable harm will occur if the stay is not granted, you're pretty much assured, very likely, of winning the third part, that the balance of convenience lies with you, especially if you have complied with requests in the past made of you under the Immigration and Refugee Act. So the balance of convenience is not difficult. The first two parts are more difficult to establish, especially irreparable harm.
Now, I would like to ask you something. Why do you bring these applications for stay motion, and who can legally represent clients in these applications?
So the stay motion is brought in the Federal Court of Canada. And it is an application that is very formal. And because it's in a court of law, only lawyers are allowed to represent clients in the federal court. So, unfortunately, you will have to retain a lawyer, a licensed lawyer, not a consultant or paralegal. And I would really, really urge clients, Dimitro, to look for someone who is experienced in stay motions because you have a very, very short time to make very important arguments, arguments that could literally change the life of your client. So you have 25 minutes to make your best pitch. And so you need someone who is experienced in doing stay motion, someone who has experience in appearing before the federal court, and someone who's not afraid to really speak before the judge in a stay motion because it could be very stressful even for an experienced lawyer. So it's a different skill set. Not everyone is willing to do a stay motion. And so for anyone not acquainted with the federal court who has not been a lot before the federal court, I would urge a client to really do your research and find someone. There are lawyers that have a lot of experience appearing in the federal court. I have appeared before the federal court many, many times, and I very much enjoy appearing in the federal court. Why? Because I have found that the judges there actually read the materials. They read everything, and when you go in front of them, they have read the material. They're acquainted with the voluminous material filed within a very short time, which I find actually really respectful. So for me, it's easy and it's something that I enjoy because I'm a litigator, I litigate, and I am very, very aware when I'm on a stay motion of the interest at stake. If I don't win, my client could be deported. If I get a stay granted, it could mean everything to my client and their children. So I take it very seriously, and I'm always mindful of how important it is to make that pitch within a very short time.
So I will not exaggerate if I say, so for instance, if there's an individual who's about to file this stay motion application, they have to find an individual who can they trust their life with, because their life will pretty much depend and the decision would be made in those 25 minutes before the federal judge.
Literally. I recall some years ago, maybe about 8 years ago, I argued a stay in the federal court airport to be deported. So I paused and I said in a very respectful way to the judge that I didn't mean to rush him, but I couldn't help pointing out that my client was likely being driven to the airport to be deported. And the judge, I remember always, it was Justice Zinn in the federal court. And he said, Counsel, I'm aware of that, but I need you to continue because you haven't persuaded me as yet. Continue. So I continue my arguments, and all of a sudden he paused and he said to the lawyer representing the Minister of Immigration from the Department of Justice, he said, when the driver got the news that his stay was granted, they turned the car around literally and they brought him back. And the CBSA officer said, I don't know how your lawyer did that, but I have no choice. I can deport you. And for me, in that moment when I heard that, it really made me realize the power of what we do as lawyers, that if we win our case, it makes a difference between driving the client to the airport or turning that car around and bringing him back. And I'm happy to point out, after that stay was granted, he went on to be approved for permanent resident, and today he is a Canadian citizen. And none of that would have been possible if that car had not turned around and brought him back and he had been deported.
So it was a pivotal moment in his life in all senses.
It was a pivotal moment in his life. And I would always remember that client. I will always remember him because he told me a very funny story. He said, and that was the third stay that I did for him, by the way. I did 3 stays for him. And the other 2 had been granted. And after a while, immigration they really wanted to deport him. So every now and then, after a while, they would call him in again, give him another date to be deported because we had filed a humanitarian and we were waiting for a decision on the humanitarian. And while we were waiting, immigration really wanted to get rid of him. And he was from Kosovo, I always remember. So the third time that they wanted to deport him, immigration said to him, I don't know how your lawyer got a stay the first 2 times, but this time, don't waste your money. Just take your money and go home. Because no one could grant you a stay this time. It's time for you to leave. And I recall what he said to me afterwards. He was laughing when he told me this. He said, well, you know what, Adela? I told that officer while he was screaming and screaming at me, he said, first, I worship God. Second, I worship Adela Crossley. Which made the officer even angrier with him and screamed at him some more. And he said, I didn't care at that point.
So yeah, that's quite emotional. But I would like to ask you something. So, for instance, you just mentioned that the stay motion was granted 3 times with a specific individual.
Yes.
So, for instance, if the federal court grants a stay motion, does it have some sort of like expiration date?
Well, it depends
Why would they file the second stay motion?
Okay. So it depends on what is the remedy that is given, right? So when you bring a stay motion, you could bring a stay motion on a deferral request. So this is what I had been doing. I had been bringing a stay motion on a deferral request. So you have the underlying application for judicial review. And so when you win the judicial review, or if you settle the judicial review, so the first stay motion, I had settled the judicial review, and the Department of Justice agreed as part of that settlement that it will go back to a new officer who will make a new determination whether the client should be deported from Canada. So that was the remedy that we would have gotten in the judicial review if we had argued it on its merit and we would have won. So when the Department of Justice approached me with a settlement to give the same outcome, of course, I was happy and I took it. But I think in retrospect, it didn't really benefit my client, because had we argued the judicial review, we would have had a longer time for leave to be granted and for us to get the same remedy that we agreed to early on. So, I mean, it would have been unreasonable not to take the offer, because it's exactly what we would have gotten, and we, did not have to wait. But in retrospect, it went back for redetermination by a new officer, like that, like really, really fast, right? And so that new officer was supposed to be a new officer who made a new decision whether or not to deport my client or to defer his removal pending the humanitarian. So on the second stay, we got a negative decision. And when I looked at the officer who, and I was doing a stay, when I look at the officer who had made that decision, I realized it was the same officer from the first.
Is it possible?
He should not have done it. It violated, natural justice, and it violated the terms of the settlement that we had arrived at. And so after we were doing the stay and we were filing the materials, when I looked at the officer, it occurred to me, hey, wait a minute, it's the same officer. So I called the Department of Justice and I said to them, it violated the terms of the first stay. And then the Department of Justice looked at the decision and say, Adela, you're right. And then they're like, okay, we'll grant you an administrative stay. So we got the second stay granted administratively. And so they didn't deport him. So it went back to another officer to make another decision. And so they came back like really fast with a decision, which was not for him to wait, not to, to wait on the humanitarian, which is what we wanted, right? So they gave him a date to be deported. So we had to go back to the federal court a third time. And this time there was no settlement. We had to argue that stay, which was granted. So that's how I end up arguing three. Well, I didn't argue the second one, but I had filed the second one. 3 stays for one client. And thank God, it wasn't a fourth stay because the humanitarian was accepted. And so that's how I always remember that client, because he was funny and he was being driven to the airport. And the funniest part of that, he never lost hope. Even when I met him in my office and they turned that car around and brought him back, and I met with him face to face in my office, I said, were you scared? He goes, never. I always believed in you, Adela. I'm like, even when you were driving to the airport, you didn't lose hope? He goes, never, Adela, never, never. I always knew. So I'm like, when you got that phone call, when the CBSA got that phone call, you were not surprised? He's like, no, I wasn't surprised. He's like, I always knew that something would happen. I don't know what exactly, but I knew something would happen and I would not be deported. I'm like, okay, you have more faith than I do.
Adela, I honestly admire your experience and your professionalism. And I want to ask you something. Let's imagine I walk into your office in the same situation where my refugee claim, well, actually, when I was found ineligible for refugee claim. What can you do for me in this situation?
Well, Dimitri, I could do a lot for you. First of all, I'll tell you, don't let the time that go by between now and when immigration calls you in for a PRRA to be an idle time. I'm very fond of telling my clients, I don't like lazy people. I like you to work hard, because hard work has its own merit. So by hard work, I mean get the evidence. So if you're saying that I'm afraid to return to my country because I have this risk, and when I tried to get help from the police, they refused to help me, I'm like, okay, get me a copy of that police report. While you're waiting in Canada for your pre-move risk assessment, get the evidence. If you're alleging that your mental health has declined because of your fear and the trauma that you have experienced, okay, get me medical documents, get me a medical report. Let me see that you're, going into counseling. So there are many, many things, Demetria, that one could do while they are waiting for their pre-move risk assessment. There are many things that they could do. They could get their family, their friends, individuals that know their situation to write letters, to do affidavits, to go get, all kinds of evidence in their home country. So there are many things that they could do. That is relating to the pre-mover risk assessment. But I always say, why not explore an alternative pathway in addition to the pre-mover risk assessment to get permanent residence? So we could be looking at a humanitarian, right? A humanitarian is based on very different things. It is not about risk, Dimitro. It is about hardship. For instance, if you were to go back to your country, the question is not whether they would be a risk to your life, but whether they would be hardship you would experience. Hardship could be difficulty in getting employment. It could be accessing healthcare. It could be, if you're a member of the LGBTQ community, it could be, are you accepted? Are you respected? Does your country value you as an individual? Do you feel comfortable disclosing that? So there could be many, many things that we could be looking at in terms of hardship. And that would be most suited to a humanitarian application. And so within a risk assessment, the fact that you may have a fantastic job in Canada, the fact that you may be employee of the month of the year at your place of employment, none of that is relevant in a risk assessment. It's not whether you're a good employee, it's not whether you're a nice person, it's whether is there a risk to your life in your country. But for instance, I know you are a fantastic employee. I know your employer really value you. So these are things that could be assessed within a humanitarian. So you could also be looking at doing a humanitarian while you are waiting for a pre-mover risk assessment. So the important thing that I want clients to walk away with, the time between now and when you get your PRRA should not be an idle time. You should not just go and look at the World Cup and forget about your immigration and just be cheering on the country that you like. You should be actively pursuing alternative ways of getting permanent residence. Maybe one of the things that happen while you are waiting, if you're single, maybe you meet someone and you enter into a meaningful relationship and you get married to a Canadian citizen or a permanent resident. They could be a sponsorship, right? So there are many, many things that we could be looking at while you are waiting. June is a wonderful month to get married, right? The summer. So you never know. Not in venture, not in gain. You go out there, you socialize, you meet someone, and before you know it, I'm getting invited to a wedding. Right? So there are many things you could be doing, and I urge you to come see me to discuss all of those ways. I'll be delighted to see you, to talk to you, and to tell you how you may improve your chances of getting permanent residence in Canada while you are waiting. Don't let that time be idle.
I was told that you have positive decisions on the agency applications for individuals who are citizens of the United States, citizens of France, and other European countries.
That is true. That is true.
What
I have received that.
what does it take to get a positive decision for an individual from a country, let's say from the United States? So I imagine you were able to prove to the immigration officer that this individual would be facing some. I would say in today's America, it'd be just a piece of cake to win the agency application. But before, yeah, I understand it was quite complicated.
Well, like I said, on a serious note, hardship is a very subjective word, right? What could be hardship for someone uh, could be very, very different for someone else. So, for instance, in one of the cases that I won, and I've won multiple cases from the United States with humanitarian, it was concerning a pastor who had come to Canada and started a church here. And for him, his congregation was like his family. His wife taught Sunday school in the church. He was very involved and he was tending to his flock, so to speak. And he saw them as like an expanded family in Canada. So I was able to really understand that for this gentleman to leave that family that he had grown by the work that he did as a pastor, he mentored them, His wife taught Sunday school to them. They were important people to him. He was there with the children. For him to lose that family, that surrogate family, and go back to the United States and start all over again, it was hardship. So I was really able to communicate that very effectively to immigration, and he was accepted because undoubtedly there was going to be tremendous hardship to him, even though he was a Caucasian American citizen. I also have had multiple positive decisions on humanitarian from the United Kingdom. And in one of those cases, I vividly recall it was a older client who had grown up in foster care in the UK, and she had never known her birth mother. And she searched for her biological mother and she found her. Unfortunately for her, her mother rejected her, did not want a relationship with her. And so she was devastated because she went through that sense of abandonment all over again. And it was very traumatic for her. And she decided that the only thing that she could do to get over that trauma was to leave the UK and start all over again in a new country. And she chose Canada. So it was an application that really made me have a lot of empathy for her. And I was able to showcase in a very sensitive way why it was that important for her to be accepted in her new country because she had already faced abandonment and rejection in her country of birth, the UK. So I think that what I would like to take away from this is that hardship is not restricted to any one experience. Hardship is very subjective and it could mean many, many different things to many different people. And my role as a lawyer on that humanitarian application is to listen and to really understand why it is important that you remain in Canada and why it would give rise to a high level of dislocation, of hardship, of trauma, even if you have to go back to your country. For instance, I work a lot with Indigenous individuals. And for many Indigenous people, they did not even identify as Indigenous until they came to Canada and they realized that there is no universal way that Indigenous people are treated. And in Canada, for the first time, many of them have felt accepted, have felt seen, have felt validated, and that's important to them, to their sense of who they are as Indigenous individuals. And so I really enjoy working with many Indigenous clients because I find that for them it's not about just economic situation. It's about being accepted, being respected, being seen as individuals, and they have never experienced that in their country. They've always been seen as inferior human beings. And so just highlighting that and how important that is to their sense of worth is very rewarding for me when they do get accepted.
I can definitely say that you are a social individual. I presume that you like meeting your clients. And again, what would to take me to become your client? How can I start?
Well, I always encourage clients to book a consultation in person with me. I understand if you're busy or if it's not possible to come in person. I do virtual meetings. And so for me, the first thing is to meet with you, listen to you, and understand what application best suit your need. Because immigration, there's no one size fits all. It's very individualized, and sometimes maybe the best way is an economic application, or maybe it's a refugee claim, or maybe it's a humanitarian. I will not know what is the best application until I meet you. I ask you questions and I listen, and I believe me, I really listen. And as I'm listening, in my mind, I am thinking, what is the best pathway to get the outcome that you want, which is permanent resident? So I would urge you, Dimitro, anyone that wish to meet with me, book an appointment. We offer a free consultation and we're very accessible. We have an office cell phone where we encourage our clients to send a message. They could text us, they could send a message through WhatsApp, and we respond to those messages and we will book a free consultation, whether it's virtual, whether it's in person. And so that's a starting point for me. And then after meeting with you, if I find that maybe now is not the right time, maybe you need to establish yourself another, let's say, 3 months, I would say to you, Demetrio, come back and see me in 3 months and check in with me. And then we'll talk about it in 3 months. If I feel it's not the right time, if I feel that you have a good chance, I will say, okay, let's discuss, let's say, humanitarian or maybe express entry, or maybe you have an employer that is very supportive of you and wishes to nominate you through, another pathway for permanent residence. So there are many ways that you could achieve the same goal, permanent residence in Canada. And until I meet with you, until I ask you questions, I will not know precisely which is the best pathway. So the starting point is come see me and we'll talk. Everything is confidential, and then we'll discuss the pathway that best suits your needs.